Okay. We are going to Ivy.
For pronouncement of judgment, item number 30.
Appeal against Zahirul Islam and Zahirul Islam is dismissed. Appeal against Azhar Ali, it's allowed. Appeal of Azhar Ali is allowed. So he's acquitted.
What's the correction?
Item number 31.
Writ appeal fails and is hereby dismissed.
Highly ordered.
It's 25.
Thank you. Wait, please.
Just hold on, hold on. Are you in a hurry to go somewhere?
No.
Okay. Have patience.
Item number 32.
The writ appeal is dismissed with cost of rupees 25,000.
Obliged.
Request for adjournment, if any, from item number 1 to 6.
Please, your lordship.
Yes.
I beg to mention item number 5, 6, and 7. As the conducting counsel for the appellant is suffering from conjunctivitis.
Okay, it's stated that arguing counsel, Mr. Saiwala is not well. And a request is made to adjourn the appeals List. on,
It will be at around 25th or 26th of September, Lordship, if it is convenient.
not in September now, 17th October.
Highly obliged.
All three will go. The three appeals, all three will go. चलिए नहीं है तो चलिए.
Made please, your lordship.
Yes,
Lordship, I'm sorry, I made a interrupt.
no, it's okay.
Lordship, I pray for listing of a writ appeal
Hmm.
any day next week, if possible, Monday,
Is a fresh matter,
not your lordship.
then what is the next date?
Next date not given, but it was given that after 4 weeks. So 4 weeks is in the meantime complete.
Find out what is the date and then get it listed accordingly.
Lordship.
All right. Next. Yes,
May it please your lordship. I beg to mention item number 25.
25, this matter is being rotated regularly. If you're not interested, then we'll adjourn it by 10 weeks now. Our request is made to adjourn the matter. We find that regular adjournments are being sought by the appellant's counsel. Thus, this consideration of this writ appeal is deferred by 10 weeks.
Obliged.
Daily list for orders, item 13.
Item 13. Yes.
May it please, your lordship.
Hmm.
In this case, service to one of the respondent, which is
Number 6, the
Six,
report is,
yes,
doesn't reside.
yes.
there.
Lordship. So we have.
So you'll have to find out correct address.
Exactly, lordship.
An advocate general to file fresh and present current address or current and correct address of the respondent number 6 within 4 weeks. You'll need some
Within
time
2 weeks, lordship.
within 2 weeks. Upon which comma notices again be issued to such a respondent. Rule is made returnable in 6 weeks thereafter.
Highly obliged.
Item number 14.
Your lordship. Lordship, this matter was supposed to be led by senior advocate Mr. Mihir Desai from Mumbai through video conference. So,
Hmm.
Lordship, I suppose he is not connected. Lordship, matter may be taken up after some time. Obliged.
Item number 15 and 16.
What has happened?
Yes, so far item number 15 is concerned, my lord. The senior judge has been informed that was absent. Today it will be withdrawn. So far item number 16 is concerned, it has been already been withdrawn.
Already withdrawn?
Yes,
All right. And the other will be withdrawn today.
today, my lord, that's
So-
in the instruction. My already money was paid to him.
So can we
Close, my
Uh,
lord.
close it?
Yes,
on
my
your
lord, my
statement-
submission may be recorded.
What do you say? In appeal number, writ appeal number 6589,
6589 would be withdrawn today, my lord.
6589, current counsel representing the respondents, private respondent number
8,
8,
4 and 5, sorry. I'm
4 and 5
4 and 5.
makes a statement that the complaint in reference where to complaint filed in Chandigarh,
In Punjab.
in Punjab for the questioning whereof the appellant has preferred the writ petition number so and so shall be withdrawn today. In view of the above statement, the instant writ appeal. Then the writ petition also will be writ
Yes,
petition,
Yes,
writ appeal as well as the writ petition number 5/4/26/2021 are closed.
public.
All right, writ petition, you get it closed in the single bench.
Yes,
Is closed, and counsel for the parties may make a mention before the learned single judge for getting the proceedings of the writ petition closed.
My lord, may I have a request, my lord? Perhaps the case that has been withdrawn is in Jalandhar. Probably, my lord, may mention it as Jalandhar
Jalandhar,
and the rest
all right,
is
Jalandhar.
Amritsar. The other one which will be withdrawn today is Amritsar perhaps.
Amritsar.
At Jalandhar.
Jalandhar.
You give the details of the case.
My lord.
Give the- Next one, because the front counsel representing the private respondents has placed on record photostat copy of the order dated 21/8/2023, as per which, the complaint filed by Rana Pratap Singh against the appellant
He
in-
expired and his father went and communicate to the court.
in the court of, in the NA, in the court at Punjab has been withdrawn. In view of the above development, nothing survives for consideration of this court in this writ appeal. Hence, the proceedings therefore closed. Then counsel for the parties may make a mention before the learned single judge for closure of the proceedings of the writ petition.
Deeply obliged.
Obliged, my
Interlocutory applications are also disposed of.
obliged.
Item 17.
Correct address.
Yes, your lordship.
There's, the respondent was earlier served on an address which is available in the writ appeal. File that address again.
Okay.
Counsel for the appellant to furnish correct address of the respondent within 7 days, whereafter process be issued. Rule is made returnable in 6 weeks thereafter. You take a note of that address. Writ appeal file mein dena. We have flagged it. Yes, that is the address. Give it to her. She'll take note. Or she'll do it in the office, all right, whatever. Continue.
Item 18.
My lord, today is fixed for filing the affidavit by SPAN number 1, 10, 7, 9, and my lord 11, 12. 9 is filed today, and I in objection filed in the IA, my lord. IA, my lord.
1 and 9 service has been completed.
Oh, no, my lord, except once, and my lord, 11 and 12, the service is not complete. But the service is completed, but now I have to file the affidavit, my lord.
My lord, I am on behalf of respondent number 11, my lord. I will file affidavit and give you some.
You have already filed,
No, I have not filed. I have to pay for some.
but they still, who appears for respondent number 1? Pharmacy
One, we
council.
have taken the steps to register post, my lord.
Still, there is no report of service.
But we have taken the steps on, my lord.
You are putting in appearance, all right. Then there is,
We taken steps on, my lord.
madam,
5,
madam is already appearing for respondent number 1.
1.
And 9 and 7, 1 and 9, 9 who is
I am appearing for respondent number 9 and.
MS Devi puts in appearance on behalf of the respondent number 1, Shri so and so. Your good name? Puts in appearance on behalf of the respondent number 9. The service is complete.
On behalf of MJ.
Give a slip. The service is complete. This is a application for condonation of delay.
No, no.
No, all right. This is the appeal itself.
This is a, my lord, this is a PIL, my lord. And
What is the IA you have filed?
IA, my lord, is for their filing some documents, my lord, by way of affidavit. I prayed, my lord, that death affidavits, my lord, IA to cancel this document, my lord. On that, my lord, file the objection. Because there's the documents are all in violation of the, my lord, this pharmacy council education rule.
Where have they filed the documents? In the writ appeal?
No, my lord, in affidavit opposition, it appeal, my lord.
Not the appeal.
Not appeal, my lord, PIL, my lord.
So We will take note of those documents when we are taking up the PIL. What is the fun in doing a dual exercise in this? What is the point?
My lord, all the documents they relied, my lord, these are all in violation of the, my lord, rules that is framed under the, my lord, Assam Pharmacy Act.
You read your prayer in the IA, and what is the prayer in the PIL? Are the prayers not overlapping? PIL, then fine. All right, we'll state the prayers made in the interlocutory application shall be considered along with the writ appeal. When the writ appeal, the PIL is taken up. List the PIL number so and so for admission after 2 weeks. The pleadings be completed in the meantime.
Lordship, I am for respondent number 7, Lordship. I have filed Okalatma by signed by wrong person, Lordship. I may be allowed to withdraw the same. Lordship.
Withdraw.
Yes, Lordship, and liberty to fresh.
And counsel appearing, Ms. Counsel so and so, Mr. MS Alam submits that he has filed a wakalatnama signed by a wrong person and he may be permitted to rectify the error. Permission granted.
Obliged.
My lord, that is given, my lord.
3 weeks. Let the pleadings be completed.
My lord.
Item number 19.
No. Define this application, appeal, then
Mhm.
delay of 370 days, madam.
Yes, please. What are you saying, sir? Our respondent number 5 and 7 have not been served.
They
You
have
are
resigned,
representing?
they have resigned, my lord. They have resigned from the job. I am representing 1, 2, 3, 4 and 6.
They have resigned, then they need not be heard.
Yes, my lord.
It's your statement. You're making the statement on what basis?
He personally called him and said that he has resigned from the job. So
Whether we can take cognizance of this statement. Hmm?
yes,
And counsel, Mr. So and so appearing for the, you appear for whom, Mr. Counsel?
1, 2, 3, 4 and 6.
1, 2, 3, 4 and 6 makes a statement at bar that the respondents number 5 and respondent number 7
7.
called him and have informed that they have resigned from the job. What do you say, sir? What's your stand now?
I said, if we find the appeal, my lord, in the meantime, review petition was filed, review petition has been dismissed. So there, in the meantime, there is a delay of 370.
So we'll condone the delay. What do you say on delay?
The delay has not been properly explained or calculated.
When was the review disposed of?
Review was disposed of on, my lord, 28 to 2018,
18.
18.
And the writ appeal came to be filed on?
Read appeal
Filed in a writ appeal.
On 26, 23, my lord.
12/3/20 was the review petition dismissed and the
21.
review appeal is filed in this year, my lord, last year.
So what do you say, sir? How have you explained the delay after the review even?
Calculation was done by the registry, my lord. That I have to, that calculation 370 days.
Yes.
Okay, even I was also shocked when I found that according to my calculation, there are a different, my lord, that 370 days delay was found.
370 days is counted from the date of review
Not sure.
because the original judgment is 9/11/2018.
Yes.
Calculation, because the calculation is done by the registry. That's why.
Whatever, sir, you know, you have come to know. So you have to explain. How do you explain? Where is the order of review or review petition?
Order the invitation, what will find in my from page 22. It is order dated 12/3/20.
Read petition or order. Read petition or order. Read petition or order.
12/3/20
12/3/20.
and your writ appeal came to be submitted in 23.
20.
So even if you exclude the COVID period, that is how the registry has calculated. What is wrong in it?
There is 370 days. As per the registry, it is 370 days delay, my lord. 370 days delay.
Yes, or no, explain. He has an objection, and rightly so.
Ultimately, my lord,
There is no ultimately in this case, unless you explain the delay, we are not considering the merits.
since there is a, after that, there is a MOU between the state government and the BTC. In the MU, there is a clause, my lord, where the finance is to be taken up by the.
That is going on merits of the matter, sir.
in the-
Explain the delay. Read your application. What have you stated?
But we'll turn to page number 23, my lord.
Hmm.
In February 20, there is a letter from the BTC principal secretary to, there is a second MOU to do it signed, my lord. That was sent.
You are
And-
going into the merits of the order, sir. We are asking you. How have you explained 370 days? It's not a matter of weeks or months. It's whole year, more than a year. Explain.
Because in the meantime, there's, that MOU has expired, my lord. So,
But that's a subsequent development. For that, whatever measures you want to take. Why the rate appeal should be entertained? We'll dismiss it then.
let it come another day, my lord.
Counsel for the applicant pays for some time to strike out the names of the respondents number 5 and 7 from the array of parties, array of respondents, and also to address the court on the application for condonation of delay, which is vehemently opposed by learned counsel for the respondents. List up to 4 weeks.
Problem.
Obliged, my lord.
Item number 20.
May I please, the lordship? Lordship, I have entered appearance for respondent number 8, my lord. I need 3 weeks time to file my affidavit, my lord.
7 and 8, you appear for
I am
8.
8.
No one comes for 7.
No, my.
Service is complete on all respondents. Thus, list for admission of 4 weeks. Pleadings be completed in the meantime.
Deeply obliged.
As per the office report, pleadings, service is complete on all respondents.
Item number 21.
May it please the lordship, my lord, I filed an IA in the delay condonation application for substituted service. Because there are more than 80, 90.
Review. You are in review of which order?
My lord, earlier order was of 2016, review was, my lord, dismissed, then we have challenged that
So now you are in appeal
appeal, my lord.
and the delay is how much?
1,751 days. Because, my lord, the review was dismissed on.
Come on merits, come on merits. All right. There's nothing in merits, Mr. Chaudhary. You've seen the order,
My lord, I
very
understand.
well reasoned order.
Let me, give me a chance, my lord, for one day.
All right, in council. Speaker Roy Chaudhary prays for time to address the court on the merits of the matter.
My lord, so the delay is condoned.
No. You will take up both the things,
Both.
delay as well as merit.
My-
On delay as well as on merits.
Obliged, my lord.
List of 4 weeks. Delay without hearing the other side. New concept you are proposing,
My lord, I thought, my lord, your lordship is.
not so benevolent,
My lord,
rest assured.
obliged,
Nobody should carry that misconception.
my lord, definitely, my lord. Obliged, my lord.
Item 22.
Retrial.
Lordship. Honorable single judge held that we could not have retired him in view of the section, Lordship. 97.
Hmm.
And since the summary court martial procedure are not required to be confirmed, that's why we could not have reviewed. But Lordship may kindly, some leeway has been given to us, Lordship.
In what?
Under
By
the
what
act,
provision?
under the act. Lordship.
Let's see. Did he undergo the punishment or not?
Lordship.
89 days punishment, did he
No,
undergo or
that is, with all respect, that is perverse finding, Lordship. That Lordship will come to page, Lordship. Because that order, Lordship is called two persons,
not?
page Lordship 27. First part is Chandrasekhar, next part is Pramod Kumar Yadav. This
All right,
Pramod
we'll-
Kumar Yadav underwent 89 days.
Third, issue notice to the respondent. Steps for service will be taken in 7 days without process be issued.
Deeply obliged.
Item number 23.
Wait, please, your lordship. Lordship, in this case, the petitioners are challenging the impugned order dated 26/2023, which is marked it at annexure 2, my lord, page 157.
Involving seriously disputed questions of facts.
Yes, my lord.
Yes, then why the writ appeal should be entertained?
Lordship, in this case, this order has been passed in violation of the, my lord, section 26(3) of the standards of weight and measures rules, my lord,
Why?
which I have annexed at page 177,
Yes, let us know.
annexure 9, my lord.
Annexure 9.
And the relevant section is at page 184, my lord.
Yes, read, what is the
My
provision?
lord, section 26 says, my lord, validity or weights or measures duly stamped, my lord.
Hmm.
Section 3 is, my lord, important, subsection 3 of section 26, where a verified weight or measure has been repaired, whether by a licensed repairer or by the person owning and possessing the same, such weight or measure shall not be put into use unless it has been duly re-verified and stamped, notwithstanding that periodical re-verification of such weight or measure has not become due. In this case, my lord, the consignment of sugar was weighed, my lord, at Rangapani Weighbridge on 26/7/2005. But my lord, prior to that, my lord, several breakdowns of the weighbridge was noted down, my lord. And I have perused that documents in my writ petition, writ appeal, my lord. Here, my lord, the honorable judge held that, my lord, the question of issuing re-verification certificate does not require, because, my lord, here this is the breakdown which was occurred at the time of women, my lord.
Let
That
us
was
see
the
how
final
the,
report.
how the single judge has dealt with this argument of section 26.
Yes, my lord. First, the submission of the petitioner is noted in paragraph 8, my lord. The learned counsel for the petitioners has referred to annexure 16 of the writ petition to project that the weighbridge where the weighment of the consignment was done was intermittently out of order since 2/12/2000 till 9/12/2005. By referring to the provisions of section 26(3) of the Standards of Weight and Measure Enforcement Act 1985, it is submitted that the repaired weight and measure shall not be put to use unless after repairing it has been duly
Come
re-verified
to
and
para
stamped.
11,
And
para
the
11.
relevant para is at page, my lord, 18.
Hmm.
In respect of the grievance of the petitioner that the weighbridge at Rangapani was non-functional from 24/7/2005 to 25/7/2005, and therefore without re-verification certificate from the officials of the legal metrology department, the weighment done on 26/7/2005 was invalid. The court is constrained to hold that expressly the claim of the petitioner has no merit, because although the said weighbridge remained non-functional on quite a large number of days from 2/12/2000 to 25/7/2005.
All right, issue notice to the respondents.
Deeply obliged.
Steps of service, the service will be effected by providing copies of the appeal to Senate Standing Council concerned.
Deeply obliged.
Item,
We can admit it, admit issue notice. List up to 4 weeks.
item number 24.
May it please, your lordship.
Yes.
My lord, this is second round of litigation, your lordship. The challenge before your lordship is, my lord, that, my lord, the manufacturing, storage, distribution, display and sale of pan masala containing magnesium carbonate, your lordship. And as per, my lord, regulation 3.1.7, your lordship, it is not permissible. I am
That's-
taking your lordship to first, my lord,
They put it for whitening as a whitening agent.
my lord.
Yes.
Page, your lordship, may kindly come to page 45
Hmm.
directly, your lordship.
Why is it a second round? What happened in the
My
first
lord,
round?
in the first round, I have been directed to approach the authority. Accordingly, I approached, but till today, nothing happened. Your
Where is the order in the first round?
My lord, that you'll also will find at page 91, your lordship. And it starts from 92, your lordship. After recording my lord's submission, para 5, my lord, in that view of the matter, this court is of the opinion that it will be desirable if the dispute is ultimately resolved.
And what the authorities have done?
My lord. And according the present PL is closed with direction to.
Yes, what have
authority.
the authorities done on your
My lord,
representation?
that you also will see page 94 onwards, my lord.
Hmm.
Thereafter, my lord,
The judgment has been reproduced, then what?
my lord, we have given the judgment also.
What has happened thereafter?
Nothing,
Nothing.
nothing.
Ms. Saikya,
And my lord,
this
there-
is, I will tell you, for the reason that I as a lawyer have dealt with these issues, of course, appearing on behalf of the manufacturers, but they rampantly put this magnesium carbonate. The only purpose is to give a white color to the pan masala. Otherwise, also now gutka is totally prohibited. It can't be. And if the state authorities are not doing it, then it has to be started immediately sampling. Magnesium carbonate will lead to, it's a carcinogenic product. And if it is put into the any of the food articles, edible articles, it is bound to affect the population at large. This is one similarity which I found in Rajasthan and Assam.
It has been banned in Rajasthan.
Large number of consumers of gutka and chewing tobacco. Same position in Rajasthan. You will find all corridors of public buildings red by this pit. It's an unfortunate thing, but it's a fact. So this thing has to be addressed immediately. Why? Firstly, you ask the authorities why they have not responded to the representation. Issue notice. Then Advocate General, Ms. Saikya, puts in appearance on behalf of all respondents.
No, well, private, I have met party.
A private respondents you met party.
Or your lordship, at this stage, your lordship may not issue to private respondent. Let
Issue notice to the respondents numbers
1 to 4, my lord.
1 to 4 only. At this stage, we are inclined, looking to the averments made in the red petition, more particularly the assertion that the representation submitted by the petitioner to the competent authority in compliance, representation dated what is 22nd January 21, submitted by the petitioner to the competent authority in compliance of the judgment dated 21/11/2020, passed in PIL number 19/2020, has not been addressed, has not been responded to till date, we are inclined to issue notices to the response numbers 1 to 4 only. Shri Advocate General Ms. Saikya appears on behalf of such respondents. Copy of the writ petition be provided to Ms. Saikya, who prays for and is granted short opportunity to complete his instructions. We'll give a shorter date on this and ask the authorities to take this very seriously. This has extreme importance, as bad as drugs, or even worse, because it is accessible to all and sundry. Re-notify on 12th September.
Only one document, if your lordship, page 90, my lord. This is a letter written by my commissioner saying that, may I read your lordship? I have the honor to inform that 43 samples of different brands of pan masala collected by senior food safety officers have tested positive for presence of ingredients anti-caking agent, namely magnesium.
Don't worry, Learned Advocate General will take care of it. We expect that he will act quickly. Yes.
Deeply.
Item number 26.
My lord, this is an appeal against the order of honorable single judge, my lord. In this case, I have been provincialized in the service, my lord. So my provincialization was sought to be interfered only on the ground that the private respondent is senior to me, my lord. Now, entire issue with regard to my lord, section 3111 is subject to the adjudication before this honorable court, and my lord has already constituted special bench.
We will send your petition there only.
My lord.
Should we send your appeal there?
My lord, my only prayer is that, my lord, by virtue of the honorable single judge order, which is my lord directed that my provincialization be kept in abeyance. I'm not getting salary, everything, my lord. So that part may lordship may take care of and then send it to the special bench, my lord. Since then, I'm not getting myself.
If you are not entertaining the appeal on the ground, that a special bench is
My
constituted,
lord, lordship
will not
will issue notice, your lordship.
issue notice to the respondent.
And my lord, judgment may be stayed, my lord. so far.
Will, by the impure heart on prayer for interim relief, by the interim order, comma, the learned single. That order was passed in February, sir.
We,
February.
we have filed an appeal in February itself, my lord.
So why didn't it come up?
My
so
lord,
far?
delay was there, then delay notice was issued. delay
No,
was
no, no,
filed,
no. This
Then
was not delay. There was no delay in this. You
Yes,
filed
sir.
it in February.
20
March.
delay was there, my lord. IA is there, lordship has disposed of the IA, my lord.
Okay, okay. So if you are yourself coming with a delay,
My lord,
hard on prayer for interim relief, is she's not getting salary?
no, not getting salary since.
By the impure order, comma, the learned single judge has directed the relegated the writ petition respondent to take recourse of the remedy of appeal under section 14 of the so and so act of 2017 and till the decision of the appellate authority, comma, the provincialization of the appellant herein has been stayed. Having regard to the facts and circumstances manifested from the record, comma, it is hereby directed that the effect and operation of the direction given by learned single judge staying the provincialization of the appellant shall remain stayed. Shall remain in abeyance. Rule is steps of service be taken in 7 days, whereafter process be issued. Standing counsel so and so appear for the state respondents.
Item number 27 and 28.
You file the affidavit?
Yes, my lord.
Okay.
As per the last order, my lord, my affidavit has been filed.
You got a copy?
I got the copy.
Yes, all right. What is the controversy? Let us know.
My lord, the annexure,
Now they said that the passport is missing. He has lost,
Passport is missing.
he has lost the passport.
no, my lord, we have filed an FIR with regard to that. In 2010 itself, my lord.
Some email have been sent to the authority asking some information.
You collect the details now. The detail will be online. All details will be available in the passport office.
I got the.
Without that detail, we will not proceed further with this appeal.
Lordship, copy of the passport and all these things I got in the affidavit, my lord. I have already instructed my.
The affidavit on behalf of the appellant has been filed. After-
May I
Howard.
submit here, my lord?
Hmm.
May I submit here?
Yes,
My lord, this is the passport which was renewed in 2011, my lord.
It was issued.
In Guwahati. My lord, may I just submit before my lord passes the order? My lord, the first passport which was issued to him was in Sydney in 2000.
Hmm.
My lord, the visa is in page 160, my lord.
Hmm. Yes,
He was granted visa on 14 June with multiple travel, but must not arrive after 14 June 2005.
Hmm.
My lord, thereafter, my lord, in 2010,
Hmm.
my lord, a GD entry was there.
Hmm.
My lord, the type copy is 161 and the original is a 162. This is in 2010 itself, my lord. 1110, received at Paltan Bazaar PS 527 1110 2010. Inquiry was made but found no traces till date. My lord, the second passport which I have given, my lord,
Hmm.
it was issued in 2011. The place of issue is in Guwahati, my lord.
Hmm. What have you stated in your application for passport regarding the earlier passport?
My lord, the earlier passport I have directly stated that, my lord, it was lost in 2010. And my lord may see, my lord, my emails that I have given to the Sydney embassy.
All right, let Mr. Nath respond.
Yes, ma'am.
Affidavit on behalf of the appellant has been filed in compliance of the order dated 27/7/2023. However, the passport held by the appellant for the relevant period has not been annexed with the affidavit on the premise that it was lost in the year 2010. must not face for opportunity, short opportunity to collect the necessary details. List up 4 weeks.
I don't, may date maybe given.
List on 11th October. 4 weeks. matlab.
Item 29.
This matter, my lord, I filed my rejoinder to the state's affidavit and the NMC has also filed its affidavit.
Who has filed?
NMC, my lord, National Medical Commission, my lord.
Lordship.
Okay.
Also filed. my lord.
So that
Hmm?
a date may be fixed for here.
What is the matter? What is the matter?
My lord, in this, my lord, we have challenged the amendment to the schedule, my lord, of the rules of 2017 of the MBBS admission, my lord, first year.
EWS.
Yes, our challenge is restricted to the amendment of the rules.
What are you doing in this, Mr. Saikia? Or what is the resolution provided?
We are
OBC.
providing 69 seats in EWS.
To who? EWS.
EWS.
In this, there is no such
No such.
bungling like that
No,
we noticed.
That is not such.
Where is it mentioned?
His whole case is lordship that we,
Where is it?
when, yes,
Where is
is
the
page 94,
page 94?
yes, 5.2.
Just let's check. Because that you have to conduct an exercise across the board. Wherever that EWS is missing, you have to clarify it. Hopefully, there is no reservations to OBC only.
No,
No?
no. This is, general also can come here.
EWS is 10%.
10%.
What about OBC? Where is OBC?
That is 27%.
27%.
Hmm?
27.
27%.
And here lordship that
No,
where
where
not-
is it? Where is it provided?
27.
It will start, my lord, from the page 88, my lord.
Let's see exactly.
Page 88,
Page-
plus 5.1 onwards. my lord.
And non-creamy layer is there lordship.
In NCL only.
Yes.
That's-
So this we have done in 2017 itself. Somehow that post-graduation, it was left out.
It's okay. Yes. So what is your grievance? in
My
this?
lord, our grievance is, my lord, restricted to page number 94. What has been done is that, my lord, the EWS, the reservation of 10% has been restricted to only 6 medical colleges. Only 6 medical colleges out of the presently 12, my lord, whereas it is a fact.
Why
Yes,
is that
Lordship.
So why is that distinction?
Yes, lordship, because the constitution permits that, enables us that up to maximum 10% we can give.
Hmm.
So it is not mandatory that we have to give 10%. So when we
Why,
give,
what is the reason for leaving out 6 colleges? There
because
must be some.
lot of general candidates will get, will lose their seats. That is one of the reason. And number two, when we gave this 10% in 2019 and 20 lordship, the central government, the MCI increased the total number of seats by 25% to ensure that 10% EWS quota can be given.
Hmm.
Thereafter, we have opened 6 new colleges.
Hmm.
So we are not getting that additional seats now. So it will directly affect the general students.
All right, do you file your affidavit?
Lordship.
The next Advocate General, Ms. Saikia, appearing for the state and who is for the MCI?
For National Medical Commission.
NMCA, National and Land Council, Mr. So and so, appearing for the respond number 3. 3. Pray for and are granted. Ms. Saikia, you will be appearing for 1,
My lord, we have
2,
already
We have
the
filed
affidavit.
affidavit.
you already filed.
Yes.
Respondent and council appearing for the respond number 3. Praise for and is granted.
He
3
has
weeks.
filed, my lord.
You also filed.
Readings are complete. my lord.
Affidavits have been filed on behalf of the respondents.
Rejoinder
for-
rejoinder also filed, my lord.
Already it's simple that readings are complete. List for final disposal in
But can it be on a short date, my lord, because
not possible, sir. No. List for final disposal on 12th October.
Deeply obliged, Lordship.
वो आज नहीं लगाया था, स्कूल वाला मंडे का लगा।
मुझे गलत है मेरे।
Passover matter 14.
Please, Your Lordship. Well, I'm sorry, my lord, the senior counsel was addressed by VC could not join, my lord. My lord, this is a matter, my lord, where my lord, we have, my lord, like certain issues with regard to the infrastructure for providing, my lord, legal aid to the NRC left out, my lord. Now, since the NRC process is in a state of, my lord, flux, my lord, my prayer is, my lord, can be so that, my lord, the matter will be adjourned sine die, my lord. We will be allowed to revive it, my lord.
Do we have any statistics How many people have been provided? How many have been deprived?
My lord,
Does your petition contain these averments?
no, my lord, our case is that this process hasn't started. We came with before.
Hasn't even started as yet.
No, my lord, the issuance of notice, my lord, with,
Hmm.
my lord, issuance of reasons for, my lord, rejection have not been, were not issued later on.
And Council Mr. Datta submits that as the process in question within bracket issuance of
Reasons for, my lord, filing
reasons
appeal
for
or rejection, reasons. for
rejection
Yes, ma'am.
of
My lord, NRC, my lord, why they are not, my lord, included in the NRC.
NRC for non-inclusion in
NRC.
NRC is in a state of uncertainty and thus consideration of this PIL may be deferred sine die, leaving the petitioner at liberty to seek revival of the petition as and when required, ordered accordingly.
Deeply obliged, your lordship.
Top of the list matters, item 1 to 4.
Your lordship.
Second is matter be taken up after some time, lordship.
But
Because senior
Can it
counsel
be
in
on-
midst of a part heard
can
matter.
it be on Monday or Tuesday then?
Lordship.
Then it doesn't come on Monday or Tuesday. These are overloading matters.
Yes, Lordship has decided recently, my lord, two matters, railway matters, and then FCA matter was all the same. Tender accepted, then,
Why don't we take it up after a while, sir? You have to go somewhere
no,
because there are no other matters now. Hardly anything.
after some time. no?
Yes, pass over.
Obliged, lordship.
Item number 8 and 9.
My lord, in respect of these appeals, my lord, the primary issues involved are pending before Supreme Court, my lord.
Is it right?
Six appeals are there.
Six. This court is apprised that issues raised in these two appeals are under consideration of Honorable the Supreme Court in a bunch of appeals
Yes.
led by so and so.
Civil appeal number 62 of 2022.
Give the copy. Thus, the hearing of these appeals is deferred by 10 weeks. Consideration of these appeals is deferred by 10 weeks, awaiting outcome of the aforesaid matters pending before Honorable Supreme Court.
Not sure.
Item number 10.
The reply. मेरा file कहाँ है?
Yes.
Wait, Lordship.
Hmm.
Lordship, perhaps recall this matters relate to the seeking of compensation
Hmm.
for custodial deaths which have occurred in the various jails in Assam.
Hmm.
On the last occasion, my learned friend had filed an affidavit whereby they have brought on record the fact that they have accepted that yes, 13 deaths have occurred in the district jail of Gwalpara.
Hmm.
But they have denied the fact that these deaths were
Unnatural.
unnatural. And also the fact that they are liable to pay any kind of compensation. So
Hmm.
now today I would like to demonstrate to your lordships
Hmm.
the various inadequacies
Hmm.
which have occurred in not only insofar as the investigation is concerned, but also insofar as the way that the manner and method in which the investigations have been carried on.
Hmm.
Lordships, if I'm just,
We are just putting you a question,
Yes,
just
yes, Your Lord.
out of curiosity.
Yes, Your
Why shouldn't you approach the NHRC or the State Human Rights Commission for this?
In some of the cases, some of the matters had been taken up to my knowledge, 3 cases were taken up by the NHRC and 2 matters have been taken up by the AHRC,
Hmm.
where in 1 or 2 cases compensation has also been granted,
Hmm.
which I have also.
Because there
raised
is a
in the
certain
chat.
element of
There
fact-finding
is,
inquiry
there
in
is, Your
this
Lordship.
matter.
The problem arises because of the fact that some of these people are declared foreign nationals.
Hmm.
They're not citizens of India.
Hmm.
That there, the problem arises.
Then otherwise also how compensation will be awarded?
Because it is Article 21, Your Lordships.
Hmm.
Therefore, and your lordships
Some-
in a Rajasthan judgment, if I'm not mistaken, your lordships have also passed an order. I do have a copy of that order with me. Where is that? I'll just place it before your lordships, wherein when your lordships were in the Rajasthan High Court, Your Lordships have passed these orders that irrespective of whether they are citizens of India or not, if they are kept in a detention center, how and in what manner they are to be kept.
But that is a different thing. That's a different thing. That's basically basic human dignity. That's
Yes,
an
Lord.
entirely different
Yes, yes,
concept.
human dignity.
Question here is that because the state is confining them, so then the state has to ensure that the human beings are kept in a dignified manner.
Yes,
It's
Your
a different thing.
Lordship.
And
It was to that extent.
entitlement of compensation.
Now, entitlement of compensation, Your Lordships, insofar as the law has developed over the years, Your Lordships are aware how Nilabati Behra, it was Rudul Shah, then Nilabati.
We
Behra,
understand,
then
madam,
Basil.
madam, we understand.
Yes, Your Lordship.
Assuming that we hold that your clients or the concerned persons,
Your Lordships.
families are
Yeah,
entitled
Your Lordships,
to
yes.
compensation.
Correct.
How do we quantify that?
Lordships, that Your Lordship would find perhaps in the case of, as an officer of the court, I should point out to Your Lordships that in the case of Sube Singh, what had happened was that the Supreme Court had taken up all the matters and it was a single person who was claiming compensation in that particular matter. After having discussed the entire law, which was in 2006 prevalent at that point of time, the Honorable Apex Court did not grant compensation in that case. The Honorable Court felt that it is not a fit case to grant compensation. Perhaps drawing an analogy from there and the fact that as per the victim compensation scheme, when a death occurs, the compensation which is granted is 5 lakh rupees in general to a victim, Your Lordships. Now, drawing an analogy from that, perhaps Your Lordships can fix the quantum of compensation as that. Since Your Lordships have posed the query as to what would be the quantum of this thing, perhaps an analogy can be drawn from the victim compensation scheme and the amount which is quantified there for a death claim is perhaps what Your Lordships might be able to grant in an appropriate case. I am not saying that all the 37 or 31 prisoners whose chart I have prepared and placed before Your Lordships, that all of them might be
Who
entitled
will
to
get
it.
the compensation?
Lordships, we may have to take a little time to take each case individually.
We understand, we understand.
Yes.
Supposing there is a person who was declared a foreign national
Yes.
and his family has already been deported, who will get the compensation?
Then Your Lordships may perhaps give it to any other organization. Perhaps the quantum of compensation may be given to a SALSA or to any other organization which works towards or in the legal aid cell. That might be done because
SALSA already has its own budget.
Lordships, the budget.
These are questions which have to be answered, madam.
Absolutely, Your Lordship. And therefore, we need to perhaps look into the matter in depth and see how each person is, whether a person is entitled to it or not. If he is entitled, then who should be the beneficiary concerned?
Because you
If
are,
there is
you
no
are in
benefit-
public interest.
Absolutely.
We don't have the details of the families.
Lordships.
So that is why we observed.
Lordships.
Why not go to the Human Rights Commission where the fact-finding inquiry can be
And
conducted?
therefore, Your Lordships, I'm saying that for us to go to the Human Rights Commission at this belated stage, because there are some deaths which have occurred way back in 2016, 17, 18. Now, for them to go to the Human Rights Commission, it might not be possible because
We,
it might be
we
a time
don't
bar
even
thing
know,
as well.
madam. We are not even having the information. Probably the families may have approached. Who knows?
I've just placed it. 3 or 4 cases, yes, they have. Some of them matters were taken up suo moto. In fact, it is in my note. If Your Lordships will just give me a minute, I can perhaps tell Your Lordships how many matters had gone to NHRC. Yes. So 3 cases have gone to NHRC, Your Lordships. The names are Arjun Saharia, Bubul Das, and Babul Biswas. And 1 case had gone to AHRC, that's the Assam Human Rights Commission, which is Amrit Das. Now, 3 of them have died in 2016 and 18. And Amrit Das, who was in Assam Human Rights Commission, died in 2019. So now for them to go and approach the Human Rights Commission might also be a belated claim, Your Lordship. Only some of them are declared foreign nationals. The others are still citizens of India,
All right.
but they might be barred by limitation. That is the only
Limitation we will extend. We will extend here because you are espousing their cause in public interest.
Lordship,
We
the
can
fact
say-
that they have already died in custody. And now the fact that they
That's
are
what
unable
we are
to-
telling you, madam, where the
Lordship.
compensation will go. How does this court decide in a PIL?
Lordships, Your Lordship's powers under 226 are wide.
Oh, so then we
Your
first,
Lordships can
first
decide
we
where
indulge in,
compensation
madam,
will go. Lordships.
before doing that, then first we indulge in the exercise, whether there are any family members
Yes, Your
to
Lordship.
claim to the
In fact,
compensation.
in my chart, I also tried to indicate whether there were any family members available in certain cases or not, Your Lordships. Which chart was this? It is correct, your lordships are absolutely correct when your lordships are saying that we will need to identify the family members. We had done this exercise in one of my, that chart, is anyone aware? Where is the chart gone?
You're talking of this chart? You've got a
Lordships,
spare,
I have,
take this.
I have several charts prepared before
Yeah.
the lordships. I had in fact faced three on three different occasions. In one of them, we had done a kind of a survey where we tried to find out whose family members were available and who were not, your lordships. No, it will. Take it off. Deepika भी ऐसा chart बनाई थी, पता है असली response number. So unfortunately, the chart which I have presented to your lordships on the last occasion, that aspect is not there. Oh, yes, in an earlier chart. Yes, your lordships, I have found it. In a minute. इसको खोलो, please. Bunch this back, bunch it up. I আরো চার্ট আছে নাকি তাতে যেটু থেকে দিলে তার আগর কিবা আছে নাকি अच्छा ये जो नया चार्ट था वो दिखाओ जरा नोट कर लिया Arjun Chowdhury has number, the number of Arjun Chowdhury in this chart. 27, yes. Lordships, in the chart which I have presented, Arjun Saharia at serial number 7 is the one, serial number 27, Lordships, I apologize. Serial number 27, Arjun Saharia. Your Lordships will see the remarks column in the chart.
Yes.
He died of hanging. An unnatural death naturally. Here, the next of kin has received rupees 3 lakhs from the IG president. Then on the next page, your lordship will take again serial number 28, Bubul Das. This is again a case of hanging. Your lordship.
Forwarded to the DC Lalbari.
Yes, your lordship.
What
But whether it has been disbursed or not, we are not aware. Then also serial number 30, if your lordship will see. Again, a case of hanging. And NHRC decided to give compensation of rupees 3 lakhs to NOK. So these are the three cases where NHRC has granted some amount of compensation.
Yes.
In the case of AHRC, we are not aware whether the compensation has actually been granted or not, your lordships. So, and next of kin, your lordships, unfortunately, we do not have the data of these people. So we are only bound by
Yes, I
whatever.
If you see suicide in the prison, the responsibility will be of the state for the reason that how do the prisoners get access to the implements? So these cases wherein either there is a suicide or there is a strangulation, or there are one or two cases wherein there is even assault, head injury by assault. Those cases
Can be segregated.
they have to be segregated. Yes.
They have to be segregated. and
So
lordship will
let's identify it
Yes,
on the
your
basis we are
that is
right
what I
now,
was,
chart right now.
Yes, your
And then perhaps what we can do is,
lordship. Lordships.
we can send it to the DLSA concerned. Let them make an inquiry and come back to us regarding the family members,
To-
District Legal Service Authority.
Lordships. That can also be done because most of the cases are of Goalpara, but then there are several other districts involved as well.
That is why we are saying DLSA.
I'm
That
absolutely.
is the
whatever
best way to
suggestion.
get the
The next
requisite
of kin, if they
information.
can identify the next of kin. Yes, your lordship.
Yes.
That would be a very helpful thing, your lordship. Endeavor in.
So now let us
My
see.
humble submission is, Lordship,
Yes.
there is a proper forum in place with a retired Chief Justice,
मुझे वो दो, NHS.
Assam Human Rights Commission.
Act-
Some of them have gone there and the
That's
honorable
right.
tribunal has said that they are natural death.
We understand.
In the list people, the listed people, Lordship, some went and the
We
finding.
understand, but it's a suicide, supposing the family doesn't have the means or the approach to reach out to the
Yes, now
ARC.
one person, Amit,
Hmm.
here, another agency went to the, because another NGO went there and found that is a case of natural death. And this
We-
now, again, this, the present.
Now
petition
this
again.
chart,
Now there is
this
a
chart has been
tug of
prepared.
war between the
Just-
NGOs now.
Just listen to us. NGO will not get anything. There's no
No,
question.
no, but one NGO went there.
Which,
And
What we are suggesting
which-
is,
that's not on
that
record, your lordships.
It is on.
hold
record.
on, hold
It
on,
is
hold on.
record, Lordship.
Please hold on, hold on. What we are suggesting is, these are cases of unfortunate deaths in prison.
Lordship.
So let's not go on the technicalities. AHRC, we can send on the basis of saying that the limitation, if at all, will stand
Yes,
condoned.
that
We
I
can do
am-
that.
I am considering that from our
We-
side also.
We don't dispute that. But where the fact is admitted that it is a suicide in prison and your IG prison has granted compensation in one
Yes,
case.
yes, Lordship.
So those
We are
cases
not
we
on-
can,
We are not.
we
on-
can segregate
Yes,
and ask the DLSA to collect the family details.
Lordship.
Then we'll get the
Yes.
information here only.
Yes, Lordship.
Why that unnecessary duplicate
Because-
exercise?
They have given a list of about 30%. Everybody is not.
Do that. Let's segregate those cases right now. You have the chart?
Lordships.
Yes, I have the chart.
So let's see. Number one, Dulal Mia, pulmonary thrombosis is natural.
But the
Next.
MER has not been provided, your lordships. The
Hmm?
magisterial inquiry report has not been provided in this case. As your lordships will find, the columns which I have made,
Inquest report is
So-
there, medical report.
medical report,
Page 44.
postmortem report not
It was not
provided.
provided, but it was done.
Where is the report?
Where is the report?
We'll segregate, then we'll ask you to present the PMR.
Now, in our affidavit, Lordship, if individually it has been, it will be taken, then we have submitted the report also. in our
Let's see. We'll pass a general order, Mr. Sakia. Observing that in those cases wherein the postmortem reports are not available, they shall be provided
Magistrate report also.
and the magistrate's reports. Heard per usual material record. A chart has been prepared from the information placed on record by Learned Advocate General Mr. Saikia of the prisoners who have expired in the prisons across the state of Rajasthan, Assam. A perusal of the chart would reveal that there are different categories of deaths of prisoners incorporated therein. In some of the cases, in the following cases,
Lordship, may I just submit, Lordship? This report is submitted by them.
this chart,
This chart.
Lordships, this is a comprehensive thing which I
Comprehensive
have
chart
made
against that.
after going
we
through
have-
all the
No, no,
affidavits. Lordships.
Against that, Lordship, we have in our subsequent affidavit, we have given everything. Let her examine. if
all right,
anything
madam,
is
what
left
you do
out.
is, from their affidavit, if you can prepare a fresh chart, come out with that.
Yes, then Lordship, it will be much
This is the
easier.
one which I had placed on the last occasion was an absolutely fresh chart prepared after filing of their affidavit, your lordship.
Where is it? We don't have it.
In the last affidavit, the only thing which they have stated is that they do not want to grant any amount of compensation. Last affidavit is not a code. where they
Now,
have filed the reply.
Madam Chaudhary,
Lordship.
and the Advocate General has very fairly said
Then
that
I-
in hanging cases, we can't dispute because we have given in few cases.
Yes, your lordship.
And the Human Rights Commission has also awarded.
Yeah, lordship. I have
So
myself
let
fairly
us-
placed it.
let us
Very
segregate-
candidly,
just
lordships. We are
Hold
not-
on. Undisputed cases
Lordship.
on the basis of their averments.
Correct.
You prepare a fresh chart.
I will do that. Absolutely.
uh, in order to supplement the chart provided earlier on the basis of the information incorporated in the additional affidavit filed by the Advocate General on 25/7/2023.
Lord.
Comma, Senate Counsel MS Chaudhary prays for some time to file a fresh chart.
Lordship, comprehensive. Lordships will kindly give me a date.
Whenever you say,
Lordships, next week, any day. 1st of September, subject to your lordship's convenience.
1st September is a Saturday.
After
It is not
7th,
possible.
Friday, your lordship.
1st September will not be possible.
Lordships,
Doesn't come
7th
upon
onwards, Lordship.
lordships, there's some personal difficulty from
13th
7th.
September.
Lordships, a little more accommodation. Next week, lordship, then in that case, 19th, 20th September, lordship.
20th September is fine.
Lordship, I'm deeply obliged.
Highly obliged.
Deeply obliged.
Item row 11 and 12.
Lordship, in this matter, I could not prepare because I have another matter online before the Honorable Supreme Court now, Lordship. So would it be taken any day?
These have been listed on your insistence.
No, they have taken three.
They have- all
They
right.
have taken
When
three
do I
of
know?
adjourn.
Forget about
In fact, I am for the other, this side, in this case.
Okay. When do you want?
No, actually, my lord, the term is coming to an end. Lordship, no, this is a matter regarding that,
Last three occasions, they took time,
no,
Lordship.
on one occasion, not
Don't go on that. What is the problem?
And we have taken time on one occasion for my personal reason.
Doesn't make any difference. You state the common date, the agreed date.
7th or 8th of September, if it is convenient to this honor.
It's all convenient to us.
Seventh, my lord.
7th September.
Highly obliged. Lordship.
Yes,
For
20
final disposal, my lord.
for
Of
final
course.
this is an hearing. Now we are out of work today.
Passed over meter,
There are two passport matters, but I appear.
1 to 4.
Yes, 1 to 4.
Yes. My lord, what happened in these cases, my lord? The petitioners are were, my lord, undertaking some transport carriage contract under the Food Corporation of India, my lord. Now, there was an NIT issued in the year 2009, my lord. Now, after issuance of NIT, my lord, certain development took place. Amongst other, one development was, my lord, the Supreme Court, by an order which is reported in yes, correct, correct. my lord. But what had happened, the practice in this part of the country was, my
See,
lord.
practice was to carry on trade illegally. Does it give rise
No,
to
no,
a exercise of a fundamental
no,
right?
I'll submit from the point of view of FCI, my lord. Now, what had happened when we used to, quote the price, we used to quote the price based on 22 metric ton. Now, therefore, my lord, when the Supreme Court order, they started implementing in May 2010.
You are equating the Supreme Court's order as this measure.
No,
Then-
not on that. No, my lord, in terms of the particular clause of the NIT, since the rate became unviable, my lord, what they should have done, they should have gone for fresh tender. That is our only case. In fact, my lord, we were selected, we were asked to deposit performance security. It was at that stage, my lord, we said we cannot perform this contract. Now the effect is, my lord, they would like to, my lord, forfeit our earnest money and, my lord, other deposits. Against that, we are before law.
Yes.
Now, as a matter of fact, if your lordship would kindly have, my lord, page number 94, my lord.
Yes.
What we would ideally submit by invoking this clause, this tender should have been scrapped.
Page 94 of
My lord, page 94 of
which writ appeal?
writ appeal number 346 of 2017, my lord. Now, this is the first page is the relevant manual, my lord,
File this.
and operative
340/17.
346.
346.
Item number, Kiman?
Rana construction.
Rana
এটা নাম্বারটা বদলিছে বোধ করলাম এটা ঠিক আছে বুঝতে নেই কারণ
বদলিব কেন আমার এতে টাকা
কারণ এবার
Rana, last item number 4, 365.
365
You're referring to
arising out of WPC 3682 of 2010.
There are
Yes.
two files of Rana construction.
Yes, my lord.
345 and 365. Which do you want to be taken?
I think it is 365. Yes.
365.
Yes.
Item number 4.
If your lordship would kindly come to page 95, my lord, clause 26.6. Workability of rates tender. Wherever the rates proposed to be considered for acceptance are more than 10% below the schedule of rate, before taking a decision in the matter, the rates should be verified to ensure that they are workable. Why I'm saying, my lord, if your lordship would kindly come to two documents, please come to, my lord, page number 99. Sorry. Let's see if we can get good. Sorry, my lord. Page number 89, my lord. It is the FCI authority, my lord. This is the facts which was communicated to the appellant. If your lordship would kindly come to the memo portion. The contractors are not providing sufficient number of trucks for transportation of food grain to Kasar district. and intimated that at Degarkhal checkpost, restriction imposed on overloading and trucks can carry only 9 metric ton, which is as per direction of the Supreme Court order. Due to railroad disruption during monsoon, FCI have to build buffer stock at Kasar district to cope up with the situation. It is requested kindly to take up the matter at the state government for exemption of FCI vehicle so the transport contractors can carry sufficient stock to avoid any food crisis thereof. Administrative exigency, my lord. Then my lord will kindly come to another communication at page 90, my lord. In fact, the FCI is writing to the Transport Authority Commissioner on 8/6/2010. I'll read from the third subpara, my lord. To unload one rack at Sangsari, which is nominated railway siding to be offloaded from wagons and loaded into the truck, at least 124 trucks are required for the purpose of unloading a rack having carrying capacity of so and so. Today, the transport contractors are required at least 294 trucks per day to offload and clear the wagon. If the loading capacity is reduced to 9 MT, the contractors will be hard pressed. Not only so, there would be crisis of food grain in the market as well. Availability of trucks and transportation of the stock to the far-flung areas are contributing factor for the controlling the price mechanism of food grains. Adequate number of trucks are not available in Guwahati for carrying food grain stock exclusively. Trucks are available for carrying coal, bamboo, cement, and other mercantile products. In such a circumstance, it would be appreciable if you could give a second thought to the restriction so imposed for allowing truck carry only, not more carry more than 9 MT as prevailing prior to 10th of May 2010. This exemption should be accorded, especially in respect of rice, wheat, sugar, or otherwise, there may be severe crisis of food grains very shortly. So, my lord, the FCI authority itself was cognizant of this situation. They wrote to the state authorities. Now, when we, submitted the rate, my lord, then, my lord, we submitted based on 22 metric ton. Now,
When did you submit the rates?
Yes.
Where is the document?
Yes.
Rates?
My lord will kindly come to page number 50, my lord.
50, yes.
Somewhere in the middle, my lord, it be pertinent to state herein that the rates quoted by the petitioners being identical during the course of negotiation, the rate was reduced from 1551 was our rate, my lord, per MT to 1470 per MT in respect of item number 3 of the tender notice dated 14/12/09. And further, the rate with regard to item number 1 of the tender notice was negotiated and reduced to so and so per day. So our rate was, my lord, 1551. Whereas the market rate, my lord, if your lordship will kindly come to 91. The market rate at that relevant point of time is, my lord, somewhere it was 2985, 2995. The moment this restriction was brought in, my lord, the price shoot up. So therefore, my lord, there was no concluded contract, my lord. We were adjust as the L1 bidder, but we never executed any agreement, neither we deposited. Therefore, our submission is, my lord, they should have invoked clause 26.6. Now, instead, what they want to do, my
Please read
lord.
that clause again.
Yes, my lord. Page 95. Uh, 26.6, workability of rates standard. Wherever the rates proposed to be considered for acceptance are more than 10% below the schedule of rate, before taking a decision in the matter, rates should be verified to ensure that they are workable.
So in a different scenario that this exercise is to be taken.
Yes.
Yes.
The only thing is, my lord, the FCI should consider our case, my lord, instead of, forfeiting our deposits. Having regard to this, they should take a call, my lord.
Yes, so what do you say?
My lord will kindly come to page 125. My lord, so far as the road restriction is concerned.
What restriction?
As the lordship got it, 125. This is a letter written by the petitioner to us,
No.
by which he had said, with reference to the subject cited above, I, on behalf of the company, would like to state that we have set for several rounds of negotiations with the office against the aforementioned tender notice issued for the work so and so, site so and so. In this connection, we would like to state that our company is not in a position to reduce or negotiate the rate further due to the following reasons. Number one, hike in diesel price, fuel price, unforeseen expenses, restriction against overloading of transport trucks, due to which the trucks owners are reluctant to do the same. And we have heard that a massive fine so and so. In the present rate of which we are doing the transportation work so and so 11245 are compelled to pay from our own pocket so and so. Next page, my lord, is the rate they have given.
Along with this letter.
Following this letter, they have submitted this, he said they cannot reduce it. We therefore decided, my lord will kindly come to, page 138. Thereafter, we said, my lord decided a committee was constituted, 138, you know. Then this is the minutes after they said that we cannot reduce because of the road restriction and
Leading restrictions, weight restrictions.
then this was considered and thereafter said we cannot ask them to reduce further, except this. They have given that their pleas were taken into consideration, and then we have accepted it. Thereafter, we issued the, my lord, the LOI, and then asking them to submit this security report. They have not. This was considered by the learned single judge. And so far as the other pleas concerned, the learned single judge.
Just consider it in that light. We may be wrong. This is subject to correction. Come to the middle of this page 138.
138.
8.
Yes.
You don't dispute that prior to this contract, the trucks were being loaded with 20 to 22 tons. Your own letters say so, right?
No, my lord. What we do is every day they have to come to us and we give them the materials. We only in the NIT say trucks or any vehicle. We have never said. We are not
You
concerned.
yourself written letters to the transport authority. Mr. Chaudhary read out that letter.
My lord,
Why were you required to write that letter?
No, my lord, we are written because under the provisions of the MD Act, the provision of MD Act, my lord, section.
Mr. Chaudhary, Ms. Roy, we don't dispute that the MV Act contains that provision. In spite thereof,
No,
you were.
MD Act contains the state government can only consider. Therefore, we have written.
We understand. Why did you write? You should have stuck. No, we will not get any reduction below what is.
My lord, they resorted to agitation. They all of them together.
Chaudhary, rightly so, for the reason that you yourself acknowledge this fact that prior to this situation, which was brought around on account of the Supreme Court directions, you were allowing 2022 metric tons to be loaded. There's no dispute about that. Is there any dispute?
We can, maybe will not we have allowed. Doesn't mean that we should continue to allow.
So, all right, now when negotiation is going on, what you write is, just read this, middle para,
Yes.
second para, at the outset, on the outset, the GMR of the committee matters intimated the lowest standards that their earlier negotiated rate of so and so for the entire distance is 18% higher than the existing contract rate. So the goods being laden in one truck are brought down to half, and the difference in rate is only 18%. How it is a.
They have said, but it is not a fact. But because, my lord, we do not quote the rate and, my lord, they have referred to the provision of the, my lord, the clause 26.6, which says schedule of rate. We have not quoted schedule of rate. We have said straightway. We said point to point basis.
Yes.
We have not given schedule of rate.
All right. There is all right. Now tell us the provision in the contract whereby the rates which you say that was arrived at by after negotiation is binding on the tenderer. Where, is there any provision in your contract?
Negotiation is permissible.
Negotiation is permitted, but what rate you arrive at in the negotiations, that is binding on the bidder. Let us see that contract.
But because it is their rate, my lord, we have accepted it.
1470 is not their rate.
Their rate.
Let's see.
Yes,
Let's
yes.
see that what was the rate offered by them.
My lord, they said, but then they reduced it. They said, we cannot reduce further, 1475.
Let us see their rates, sir.
Yes, my lord. Lord, you will kindly see the rate offered by us says 1475.
He has offered this,
1470
Ms.
is
Chaudhary, Mr. Roy, come to page 127,
127 is the rate.
offered by Psychiatrade,
Yes.
Right.
The petitioner is
Rana.
other bidder.
So where is Rana's rate? These are documents of Psychiatrade, not of Rana. Psychiatrade is not before us. Where are the rates of this appellant?
130, my lord.
1470, my lord Rana.
130.
130.
132.
So he has offered 1516. You decide to reduce it to
My
1470.
lord, he 132.
Yes. One 32.
Yes, 1470.
Hmm. Right. 1470.
So this is was referred to, my lord.
Yes.
15.
So, my lord, they have offered, they said we cannot reduce it. We said, yes, okay.
Hmm.
So after that, my lord, how can they, my lord? And my lord will kindly see their prayer now in the main writ petition.
What is the
Would
prayer?
your lordship will kindly come to page, prayer in the writ petition, page 59. Can your lordship allow this prayer, my lord?
Yes, just let us read that, sir.
Impugned tender notice should be satisfied. And then the letter dated so and so. So and so, and they at page 61, they say they want to revise their rate. Can your lordship, my lord, allow this revision of rate now, my lord?
There is a prayer for recalling the entire tender also.
Yes. There's
a prayer.
Now, your lordship, after so many years, would your lordship like to?
Yes, Mr. Chaudhary, show us law. Which can.
My lord, let me put it very simply, my lord. When we file this writ petition, we file with a prayer to set aside the tender amongst others. On 7/6/2010, my lord, in the court, they came up with that order that we have accepted your rate. When we filed the writ petition, my lord, that was not there. Then we, my lord, filed an IA when that order was also stayed.
The tender was accepted thereafter.
Yes, my
Filing of the writ petition.
yes. When petition was being moved, then a fax was produced before the honorable court on 7/6 saying that they have accepted our rate. But our case is very simple. By that 7/6/2000 letter, they said we have accepted your rate. Now you deposit your.
But that rate acceptance was in terms of your own agreement undertaking.
No, my lord, my rate was valid only up to 36/2010. Please come to page 130 for a moment, my lord.
Yes.
Only up to 36/2010.
So they accepted on 7 June. They accepted.
But kindly see, my lord, we agree to keep the offer open for extended up to inclusive of 36/2010,
Yes.
not beyond that.
And when did they accept it?
My lord,
7 June. So they accepted it
But
before
that,
that.
that was stayed by this honorable court, my lord.
That's a different thing. That's a
Yes.
different thing.
No, my lord, our
Saying it is a different thing.
my lord, it's not that anybody has suffered any prejudice or anything. Thereafter, They have gone.
These are contractual matters, Mr.
True, my
Chaudhary.
lord, true.
Strict,
So all that I'm saying is let them
Strict
consider, my lord, having regard to the peculiar facts of the case, let the highest authority of the FCI take a call.
show us the law on the point.
No, my lord, my only submission is in terms of clause 26.6, they should have find out whether this work is workable.
That aspect was discussed in the negotiation committee.
No, my
That
lord.
is what the
No,
discussion
no,
is.
that is a separate exercise, my lord. That was never done. So something like at the threshold only we came, my lord. There was no concluded contract. It's not, if you
No,
would
no,
have-
concluded contract, they accept that his contract is concluded. We already held in the railway matter. It's no question of communicating or signing the contract which would conclude.
No,
That
my
is
lord,
not
even,
required.
even security deposit was not furnished. Performance guarantee we were supposed to give, that we did not give.
Mm.
So where is the question of concluded contract? My lord? My lord, yes, in an appropriate case, even non-signing also may, amount to a contract
Yes,
having been
it
concluded.
was your offer
Uh.
which they accepted. And that very moment, they contract was.
Suppose, my lord, section 39 of the contract, Act, I as a promisee, my lord, I did not pay, perform my part. Therefore, there will be no contract.
No, then they will take the necessary remedial measures
Therefore,
for you in the future
therefore,
contracts.
my lord, our humble submission is, there is no dispute that they wrote to the government of Assam.
Mm.
At the end of the day, we have to procure trucks. We do not have 294 number of trucks to carry the food grains to Kachar.
Was it considered, Mr. Roy? Was it considered at any higher level, their grievance?
No.
No, my lord, it was not required. Only that letter was written, but otherwise nobody
So
considered.
in light of that letter,
Yes.
which your authorities have written to the state government,
Government of India has filed their affidavit, my lord. Government of India has filed their affidavit. Government of Assam.
uh,
They said they cannot go beyond the rules. They have said.
that's all right. But you yourself concede to the fact that it was a practice going on in the FCI that you are allowing 2022 metric tons to be loaded. There was a practical difficulty even as per your letter that so many trucks will not be available. In that light, the peculiar fact, the things tilted after the judgment of the Supreme Court.
Yes.
No, my
So
lord,
you could have taken a little
lord,
bit of pragmatic
it
approach.
is the final authority. There may be notes, my lord. Final authority, which is to take a call. They have the final authority has.
This required a decision at a higher level.
Yes.
Higher
Not
level
at
means,
this.
my lord,
They were, of course, hell bent upon it. Otherwise, responsibility would have fallen on them. If they had not accepted it, the responsibility would have come on these officers.
No, my lord, had there been no negotiation on this aspect,
We
the
understand,
matter
sir.
would be different, my lord, altogether.
We would expect that your executive director should
Take a call.
take a call on this.
Yes, yes.
My lord, executive director has nothing to, he cannot accede to it because he cannot also say that they should be allowed. to-
Let the chairman do it then. Let the chairman FCI take a decision. We allow them to file a representation.
Yes.
Let the chairman FCI
Yes.
decide things. Till then, this stay will continue. What do you say?
Yes.
I don't think there is a stay. My lord. Stay is with regard to risk and cost only. Risk and cost. Otherwise,
What happened to the performance
No,
securities?
my lord, no,
No.
they have.
they have not.
They must have,
Otherwise, my lord, but for the proceeding, they will,
you would
forfeit
have,
my performance security.
that has already been
That is done.
forfeited.
No,
That
that-
is done.
Now it's a question of recovery.
Recover.
That has been done.
What is it?
That has been forfeited, obviously.
Forfeited.
So now you make a submission, a representation.
Yes, in the peculiar facts, my lord, let them consider.
During the course of submissions, senior counsel, Mr. Chaudhary, has drawn the court's attention to two communications issued by the executive director, area manager, and the executive director, respectively, of FCI Northeast Region, within bracket annexures H and annexures I, dated 7/6/2010 and 8/6/2010, and urge that the FCI officials themselves realized that there was a sudden change in scenario by which, the earlier practice of allowing overloading of trucks of food grains to the extent of 20 to 22 MT was curtailed to 9 metric tons only as per the Supreme Court's order. The FCI authorities wrote to the state government seeking relaxation, public exemption to the trucks of FCI. Mr. Chaudhary urges that in view of this sudden change, whereby, the carrying capacity was required to be reduced to almost 50%, less than 50%, the price offered by the appellants herein became unworkable. Thus, an exercise was required to be conducted in accordance with clause 26.6 of the storage and contract manual of FCI. He thus submits that the appellants herein may be permitted to make a representation to the chairman FCI or officer authorized by the chairman in this behalf, and an objective consideration of such representation may be made. Mr. Roy, Senior Counsel representing the respondents, has opposed this submission. However, in the interest of justice, we feel that the appellants herein deserve to be given an opportunity of representing their grievance to the chairman, who shall representing the above referred grievance before the chairman.
CMD, not chairman.
CMD. Accordingly, the appellants are given liberty to submit a detailed representation addressed to the CMD FCI, who shall either himself or by an appropriate officer delegated for this purpose, get the representation examined and considered objectively.
But till then, no coercive, because they might blacklist us also, my lord.
Long back, 5 years.
No,
long back.
this is a long time, 5 years, 6 years, the appeal that the exercise has indicated above shall be completed within next 6 months, the 6 weeks. The representations be submitted in 7 days, 2 weeks. And the consideration thereof shall be made within 6 weeks thereafter. List after 8 weeks.
Lordship, in item number 2, my lord, we are no longer appearing in this matter, my lord.
Then we'll dispose it of.
Same line.
Counsel.
I
Let
think
the order
already
remain.
in the
Let the
same
order-
line, it can be disposed of. Okay.